single campus churches. It's Wednesday through Saturday. Stays in dorm. We'd rather be.
Conference will now be recorded.
I have a feeling that I'm here, but I'm not here this morning.
All right, it is 10 o'clock, so we'll go ahead and call this meeting of the County Commission session. Let the record reflect that the quorum is present. This meeting has been called in accordance with the Texas Open Meetings Act. And with that being said, Madam Clerk, do we have anybody who has requested public comments?
No, sir, we did not.
Okay, so that will take us into item number 2, which is the consider, approve, and informational section. Item number A is a second reading of the proposed regulation of subdivision of land, including manufactured home rental communities pursuant to Local Government Code 232 of the Texas Local Government Code. With that being said, we will need a motion. Is that correct, council?
Yes, sir.
Okay.
I'll make it.
There is a motion. Is there a second?
Second.
Okay. So we now, all in favor, aye?
Aye.
Okay. And we will go into item number A, and that's the second reading. Council, for the court this morning is Mr. Bob Bass with Allison Bass and McGee. They do provide legal counsel for the court. We do not see anyone present. There may be those who are viewing by way of our live broadcast that we're doing on YouTube right now.
I'm going to walk through the various sections of the proposed regulation, laying out what's in that section and why it's in there. I'm not going to attempt to read per se the document, but merely go through the document topic by topic. The introduction is on the first page of the proposed regulation, merely lays out the rationale for the adoption of a subdivision regulation. That's followed by 3 pages of specific index references where various topics are covered. We then turn to chapter 1, page 5 of the regulation. This is a recitation of the statutory authorities upon which the court is authorized to adopt subdivision regulation. That is spread out among various chapters and volumes of the Texas codes, principally Texas Local Government Code, Chapter 232 and 233, Chapter 242, and Chapter 251 of the Transportation Code, the Health and Safety Code in Chapters 364 and 366, and the Texas Water Code in Chapter 26. Those are illustrative references to the statute. That is not necessarily all inclusive. There may be other places in the statute where various authority is delegated to the Commissioner's Court. 1.1 is the definition of what a subdivision is, being a subdivision of any tract of land into 2 or more parts to lay out a subdivision of the tract, including an addition or lots. And most importantly, anytime a plan or plat lays out interior streets, squares, parks, or other parts to be intended for public use or for the use of purchasers or owners of lots that front or adjacent to those streets, alleys, squares, parks, or other parts, requires that subdivision of land be approved by the Commissioner's Court. So the statute in concept is very broad, and a plat then is required for such subdivisions. And 1.2 lays out what needs to be in a plat application. 1.3 contains certain exceptions to the platting requirement. These are drawn from the statutes themselves. A subdivision of land is exempt from a platting requirement if it is intended for ag use and there are no interior streets, alleys, squares, or parks. It's intended to be used for agricultural purposes. If it's converted to some other use, then it comes back under the statute. A transfer of land in a family is exempt if it's dividing into 4 or fewer parts. And again, there are no interior streets, alleys, squares, or parks, or other common areas. If the transfer of title to any of those subparts must be within a 3rd degree of consanguinity or affinity to be considered a family tract. Within 2 years of the original division, if there are subsequent transfers to non-family members, that subdivision of land may fall back under the Act. There is an exception for tracts that are divided into larger, 10 acres or more is exempt unless, again, there are interior streets, roads, parks, or common areas. So that interior streets is very important that you look at that as part of determining whether or not a plat is required. Parcels of land that belong to the state or other state agencies are exempt. A division of land into public floodplain tracts is exempt if the land belongs to some other political subdivision and there's no interior streets. There are 2 tiers of development in this proposed regulation. A first tier development is any subdivision that lays out a part of the tract as streets, alleys, parks, or squares. In other words, a typical subdivision that comes off a main highway has interior streets to access the lots in that subdivision is a first tier subdivision. Second tier means a land division that includes not more than 4 lots, and each of those lots is accessible directly off of an existing public road. There's no interior streets. It comes off of an existing road, whether that's a state highway, a county road, or whatever. There may be, even there though, some need for determination of whether or not those lots, if they're developed, there should be a simple plat filed of record so that it can be determined if there's drainage issues. There should be a certificate from the developer confirming setbacks from highways under the normal regulation. And any access culverts that are installed need to meet a minimum dimension of 24 feet and of such diameter as the county commissioner may require in that area. If a on-site sewage septic system is proposed for that Tier 2 subdivision, the Tyler County Fire Marshal or other delegated officer should comply, may certify that it complies with TCQ rules. Subdivision naming is in 1.5. That needs to be cleared with the 911 coordinator. If there are any under 1.6, any conflict with these regulations and other law, these rules would rule. The more stringent of the 2 would rule. If some part of the regulation is deemed to be invalid, that does not defeat the other parts of the statute. County is authorized to delegate its authority to individuals, as the case may be. That could either be a county engineer or some other designated person. The effective date of the ordinance is the date it is approved or adopted. Section 1.10 is the definitions that are referenced in the statute. There are 20 separate definitions. I'm not going to go through those, but they're words that are referenced in the ordinance itself and need a definition to be understood. Chapter 2, beginning on page 13, is a beginning of what kind of water standards are required. You have essentially two options. One is through a public system or a water corporation. The other is to supply drinking water through a well. And if the well option is used, there needs to be certification that the well water complies with TCEQ regs. Wastewater is treated in 2.3 on page 14. Wastewater is also maybe provided through a system, meaning an organized system, whether it be municipal or private. And then the other option is a on-site sewage septic system. Again, that system, septic system would have to be permitted in compliance with TCEQ rules and regulations. Gray water systems could be used under the regulation as long as it complies with TCEQ standards. There needs to be in any platted subdivision provision for utility easements of not less than 15 feet. Surface utilities are to be placed within 5 feet of the property line, subsurface within 10 feet of the property line. All of those easements should be described and shown in a plat or any deed transferring title to a lot under this regulation. 2.6, if water is to be provided by a public water system, there should be firefighting connections in that plan. Housing densities would be regulated by TCEQ standards if it's an OSSF septic system. Any water wells that are used to provide water in the subdivision have to be built in compliance with TCEQ regs. Chapter 3 is the minimum standards for roads and streets, calling for a 60-foot right-of-way and a minimum setback line of 25 feet from the edge of any public road, and or 50 feet if it's from the edge of a major road. A major road would be all state or federal highways and any county maintained road that is specifically designated by the court as a major road. Streets, roads, and alleys would need to conform to these regulations. Any subgrade utilities would need to be buried at least 36 inches below drainage ditches. All other crossings are board crossings. Dead end or cul-de-sacs must have a radius of 100 or diameter of 140 feet. Intersections would have to be at 90-degree angles to each other unless terrain makes that impossible. And then a variance would need to be sought under the rules of this regulation. Where a street on 3.3 covers where subdivisions connect to each other, there should be connectivity between them where possible. 3.4 contains an important note. Plat approval by the court does not mean that those streets in the subdivision are being accepted for public maintenance. That would require a separate petition for maintenance and approval by the court accepting certain roads within that subdivision for maintenance. 3.5 lays out the standards for the subgrade and flexible base under any subdivision street. 3.6 talks about surface materials that will be used in finishing streets. 3.7 requires a minimum crown of 2% of elevation across the slope. Any seep areas are to be marked and taken into account with the proper drainage. 3.9 requires coordination with the East Texas Council of Governments on 911 and rural addressing of those streets in the subdivision, so that any street would not be similarly named to an existing street. So if dispatched, there would be no confusion as to where that road is located. 3.10 talks about setbacks. At this time, as I noted, 25 feet is the minimum. It can be up to 50 feet if a major road is addressed. The only major roads at this time are state and federal highways. However, if the Commissioner's Court at a later date wants to upgrade a county road to major roadway or highway designation, you can do that, and then any subdivision plat thereafter would need to have 50 feet setbacks from that county road designated as a major highway. Minimum standards for drainage are set out in chapter 4. This would take into account any topography, floodplain requirements, so forth and so on. A subdivision itself should be designed so as not to cause any detriment to downslope landowners. So it needs to have an engineering study done as part of the platting process. Drainage ditches and structures should be designed in such a way that the property in the subdivision does not have standing water or flooding itself. 4.3 requires any developer, if necessary, to dedicate drainage easements to the purpose of preventing floods or flooding under heavy rains. Tyler County itself, however, does not assume responsibility for maintenance of those easements, but they must be laid out on the plat. Chapter 5 is a section that pertains to recreational vehicle parks. It's rather extensive. It runs for 3 or 4 pages, and it contains considerable detail on what a person who wants to develop a recreational vehicle park would be required to do. I believe that does not apply to people up to 4 spaces on their land. Anything over that would be considered a recreational vehicle park. Does not apply to temporary parking, but only to that intended to rent spaces essentially. Chapter 6 is beginning the application process. It lays out what is required in an application, the steps that will be taken by the court or the county in reviewing that application. And it lays out, the subdivision reg lays out a fee schedule for plat application fees. Chapter 7 lays out survey requirements, what is required to be reflected on the face of the plat, and that's, again, rather extensive. Chapter 7.2 requires the plat and to be prepared from an actual survey, and that a engineer by the survey of the plat has to be prepared by a professional land surveyor. The plat should reflect that individual's license number, address, and seal. 7.3 talks about the scale at which the survey should be drawn, and it would be on the size of the plat itself, 11 by 17 or no longer than 24 inches by 36 inches. There should be a digital copy of the survey as well, unless the surveyor certifies that they do not have the technology necessary to prepare a digital map. Chapter 8 lays out the approval procedure, the process. This is lifted straight from the revised statute. The court will have 30 days from the submission of a complete plat application by which to review the document. You have essentially three options after the review period. One is to approve the plat. Two is to disapprove it if it fails to comply with the regulation. Or three is to provide a conditional approval, which lays out what is yet to be completed in detail, citing the chapter and verse of the regulation. Once you've given them that notice, that stops the clock until they comply. There's not a deadline on the compliance, but those things are laid out and lifted from the statute. Chapter 9 is the section on financial guarantees. Requires the posting of a bond of 100% of the anticipated cost to develop the infrastructure of the project. It sets out the standards that the bond must meet. The bond is to cover performance bond, to build out the system as it's, or the subdivision infrastructure as required by this regulation. And then there is a 2-year period for maintenance of that structure after construction. Make sure it stays in good working order for at least 2 years after completion. The bond can be extended for construction if necessary to complete the project in a proper manner. Chapter 10 is the section that covers revisions or cancellation of subdivision plans. Again, this is generally regulated by Chapter 232 of the local government code, but it lays out here the procedures for a plat, replat, or amendment, or correction, or cancellation of an existing plat. Chapter 11 is the section that allows for variances. The court would have to approve a variance. Very rarely would variances be granted as a practice, but they are available if there are special circumstances or conditions that affect the land, such that a strict application would deprive the applicant of the reasonable use and enjoyment of their land, so long as granting the variance is not detrimental to public health, public safety, or welfare. So there is a provision for variances. Chapter 12 is your enforcement section. You can enforce these rules by litigation, injunction. In some cases, for a subdivision that's built without any compliance, that would constitute a Class B misdemeanor. Your county attorney would be the appropriate prosecuting attorney on that. On the face of the plat, under Chapter 12, there are notations that are required. The first one is a notation that merely because the plat has been filed or approved, that it doesn't indicate that Tyler County would assume responsibility for maintenance of the streets. If you choose to do so, you can do that, but that would be through an application and an approval of the street or streets that you choose to take into the public road system. On a lot or tract that is to be served by OSSF or septic systems, there would be a requirement that the plat itself contain this notation. Tyler County makes no representation that adequate sewage facilities will be legally feasible within this subdivision, and that all OSSF systems must comply with regulations published by the TCEQ. The final notation is that Tyler County makes no representation that adequate water suitable for human consumption will be available within this subdivision. Now, those are protective measures to protect the county from claims that you're going to have to provide sewer or water. Generally speaking, the TCQ rules would require that certain water standards be met and so forth. So generally speaking, this regulation requires the developer to demonstrate that they've been able to satisfy TCEQ rules. There then is an Appendix A, which is an application checklist. I recommend that someone on staff be trained to go work through this checklist so that when an applicant comes in, it's immediately given review, and the county employee asks the developer to show them each item that's on this checklist. If it's there and it helps to make a complete application, the reviewer would initial that it's satisfied. If it is not satisfied, the blank would indicate that needs to be done before the plat is complete. Only when you have every check mark checked off as complete do you have a complete application, and that's what starts your 30 days. So it's very important that that be done every time. Otherwise, at the end of 30 days, if you haven't acted officially on approval or disapproval or conditional approval within 30 days, it becomes approved as a matter of law. And so I can't stress enough how important it is to get somebody ready to review these things, to be familiar with what's in the regulation, be able to read a plat and see that everything that's on this checklist is there. You then have a series of appendix that are referred to and required by the regulation. And so those are things that you need to be familiar with. There's certifications by the owner if it's an individual, a similar certification if the developer is a legal entity like a corporation. There should be a evidence of utility availability there. There should be the utilities should be advised that unless there is an approved plat, they should not connect their utilities to a subdivision parcel. There is a certificate of the surveyor, a certificate of the engineer, a certificate for on-site sewage facility installers that they have that the lots are suitable for connection to septic systems. If the roads are going to be maintained by the developer, there needs to be a certification of that. If they intend to seek maintenance from the county at the end of the 2-year period under the bond, then they need to tell you that so that you can make sure that you've inspected the streets and determined that they are suitable for county maintenance. You're not obligated to take them. There is a place for the clerk to certify that the plat has been approved. There is an application for permit to construct any improvements in the right-of-way. That would be access culverts or streets. Any construction within your right-of-way would need to be permitted. There is a appendix for minimal standards of width, right-of-way, grade, so forth and so on. Then there is Appendix N, applies to revisions of a plat. Appendix O is any lien holder's acknowledgement of a plat revision. Appendix P is a certificate of the developer that lays out the subdivision name, the number of lots. If there is a lien holder, they need to have a lien holder's acknowledgement. Appendix Q is the development fees that are laid out would be approved by this court. So that's a walkthrough of the general subdivision regulation. Chapter 232.007 says that a manufactured mobile home community is not a subdivision plan, and that if you want to have minimal standards for such manufactured homes, subdivision rental community, in other words, a RV, a manufactured home or mobile home park that will lease or sell spaces, that if you want regulation of that, you have to have a separate regulation. So I'm going to walk through that regulation in a similar manner as I just have with the general subdivision regulation. This is a little more abbreviated regulation. It defines what a manufactured rental home community is. This is really precipitated by federal law that defines what a manufactured home is. A manufactured home generally will be brought into a site on a chassis with wheels, and then it'll be put on a foundation and the wheels will be taken off. It will have a tongue that has a federal identification stamp on it. That does not cover RVs. They're not regulated by this ordinance. That's under your general subdivision. Before any subdivision of land can be developed with the intention of making it a manufactured home rental community, they would have to present an application to the court, to the county, showing street alignment and the lots or spaces, how they're going to be designed. The designated individual for the county or the commissioner for that precinct would be able to review that application to determine if there's adequate room. But essentially what we're trying to prevent is putting those trailers in such tight quarters that it makes firefighting and the like difficult, if not impossible. Utilities cannot be connected unless a survey and infrastructure development plan for that development has been approved by the Commissioner's Court. Section 4 of this regulation requires that a plat be prepared and approved. The drawings, scale of the drawings and so forth is laid out. requires the nature of the subdivision, the name, similar types of things on the plat as you see, but less stringent than the general ordinance. The layout of those spaces needs to indicate where any floodplain boundaries might be. It needs to lay out spaces, drives, roads, internal streets, utility easements, and the like. Floodplain and drainage information needs to be laid out by statute. If there are to be on-site sewage, that again has to have proper certification from the installer and compliance with TECQ rules. There should be a certification by a registered land surveyor. If there is overlap with the city extraterritorial jurisdiction, the city should also be involved in the approval process. Street standards require that there be an all-weather drive installed. The subdivision regulations requires a paved road. The mobile home just merely requires all-weather, but it should be able to support emergency firefighting equipment and the like. This ordinance also provides for construction bonds and maintenance bonds. Those can be either in the form of a cash bond or a suitable surety bond. Once the court has reviewed the infrastructure plan and the plat, you should approve it within the same 30-day period. There is a provision for review fees, and there is a severability statute or provision as well. That is the content of the manufactured home rental community regulation. Any questions? All right, Judge, we've completed the second reading, so we're ready to go into the public hearing.
Just a clarification for my hearing. I heard you reference TECQ. That's TCEQ and TECQ, same thing. That's what you're referencing, right?
Yes, TCEQ. I may have misspoken.
Okay, very good.
Texas Commission on Environmental Quality.
Okay, good, thank you. All right, with that being said, that concludes the second reading of the proposed regulation of subdivisions of land, including manufactured home rental communities, again pursuant to Chapter 232 of the Texas Local Government Code. That being said, it is recommended by council that we recess this meeting of the Commissioners Court in order to open up a public hearing on the topic of subdivision regulation for the purpose of receiving public comments. And then we will, once we've heard any of those which may be presented to this court, we will close the public hearing on the topic itself. That does require a motion, and the chair will await a motion to recess this meeting in order to open up the public hearing portion of this meeting. Is there so?
So moved.
Is there a second? Okay, there is a second. Comments? Hearing none, all in favor, aye.
Aye.
Any opposed? Okay, so we will recess this meeting and now go into the public hearing portion of this topic itself. I'm not aware of anyone who has requested to speak in regard to this particular topic, and do not hear anyone in the room who has indicated.
Sorry. Okay, he mentioned it, and Mr. Bass, Mr. Bass?
Yes.
Okay, Mr. Bass. ETJ in working with the city, are we looking at fire protection, or are we looking at water that's supplied outside the city limits? And we would need both the city's approval and the county's approval?
If either, you're supposed to have an interlocal agreement with each city over which governmental entity will regulate development in the ETJ. If you don't have that, and I'm not aware that you do, then you would need approval for any development within the city's ETJ from the city.
Okay, specifically because they give them the water, they give them the gas, they give them all those municipal, all those
Right.
things, whether it be fire protection or anything.
And so before that development could be built, you need to show that not only has they met county approval, but also city approval.
Just for clarification, ETJ is
Extraterritorial
extraterritorial jurisdiction, which is that space just outside the city limits of an incorporated city and before it actually is acknowledged as the unincorporated portion.
Correct.
There's a little boundary that
And it
exists.
varies by the size and the type of municipality. There's classes of size for municipalities, so. And I'm not aware of any regulation, any larger than the standard 1 mile buffer.
Really? Because we have some cities that have all their utilities going 7 or 8 miles outside the city.
Well, again, in that case, they can extend their sewers out as far as they want to. Typically, they will do that within their ETJ, but they can accommodate needs outside of their ETJ.
And we just still need to work with them on getting approval.
Correct.
That they can produce what they need to produce for this park or this subdivision.
Correct.
Good questions. Anything else, Ken?
No, you got the other.
All right. Any other comments regarding the topic?
On the 2-year after construction, that they have to maintain the roads of subdivision developer, when does that 2 years start? When all the lots are sold, when all the houses are built? When does
Well,
that
the way
time
we
period
used to do things is different than the way we need to do them now, because the plat would be approved by operation of law within 30 days, so they haven't built out. So that bond would stay in place as long as they are constructing the infrastructure. And once they've completed the infrastructure that they're gonna build, then the 2-year maintenance bond.
starts at that time?
Right.
Infrastructure's the end of the infrastructure build.
Right, and now if they're wanting to do, if they're gonna do phases, they ought to do a separate application for the second phase. In other words, they should have a certain set of lots they're gonna develop at a time. Sometimes they do it all at one time, sometimes they want to do 50 homes, sell those, and then develop the second half. Any subsequent phase ought to be under a separate application. That way you can better keep up with the bond requirements.
Good week.
So I see the process changing pretty dramatically from what we've been doing. So as it has been, when someone brings in a plat, I make sure they have tax certificate on there. And then I tell them to get with the commissioner, so that he can inspect the area. And then we put it on the commissioner's court agenda. So now I'm hearing that they'll also have to have a bond and then all of these certificates.
Yes, ma'am. And so that is why somebody needs to be designated within the county to review the plat application. And it should not be filed with the clerk until it's been approved.
And we don't have a plat application either.
Well, that's
Yeah,
involved in
that was one of those
one of
pendings.
the appendix. So it will require a change most likely in what you're doing now. But it's very important that we get ahead of that by getting someone designated, whether that be a staff person that you already have on payroll, with references in the ordinance to a fire marshal, or sometimes it's referred to as a code enforcement officer. Sometimes that's an engineer that's retained by the county to review the plat. But whoever it is, the court needs to designate who that person would be, so that if somebody comes into your office, says, I have a plat, I would like an application, I would like to file, you would refer them to that person for review. Only when it's complete would it come back to your office for filing, and that starts the clock.
For the 30 days.
For the 30 days.
Yeah.
But if you were to, for example, under current rules, you accept the application and then refer it to the court, there's really not a chain of command there to show that you, in 30 days, you can get away from it. So if you file an application without it being complete, the clock starts with your acceptance of the application. And you, before you know it, your 30 days are gone and it's approved as by law.
So in that 30 days, if we got it on the agenda and it was incomplete application, could that be a cause not to approve it because it's an incomplete application?
Yeah, in other words, it shouldn't come to the court until it's complete.
Okay,
If for some reason when it gets here and you find that there's something missing, you can stop the clock,
okay.
but you've got to give written notice to the applicant what's missing. And, and that leaves whatever remaining time is on the clock. And that, then when he returns his correction or completes the application, whatever's missing, then that clock starts up again with whatever time is left. But don't wait until you've only got less than 72 hours, because you won't be able to get it on the agenda.
Okay, so this application, so the starting of the clock, is it when the application is filed in my office with the plat, or is it when the application is filed with the designated person by the court?
It starts with when anybody from the county accepts that application and without review or otherwise.
Even though it's been incomplete?
If it's incomplete, the stop clock still starts until you flag it as incomplete. So somebody's got to review it up front.
Yeah, because I'm thinking if they file it, that person needs to go, because I'm thinking if it comes to my office, we're gonna make sure all the boxes have been checked and that sort of
If
thing.
you've been trained.
Before we would put it on Commissioner's Court.
Correct.
agenda.
Yes, ma'am. It needs to be someone who's familiar with the rules and the regulation and is able to review the plat, look at the plat, read the plat. Does it have contours on it that meet the regulation? Does it have drainage certification? I mean, there's quite a few things that need to be there. And so, I'm thinking that probably wouldn't be something your office would normally
I
do.
hope not hearing that.
And so if somebody is trained to do that and they then deliver it to you as ready to be filed, certainly at that point, the clock starts.
Counselor, are you familiar with any counties who have moved into this type of oversight and responsibility, may sub that type of work out to, say, an engineering
I
contractor?
haven't kept count, but Anderson County is one place you might look. Montague County is another. Van Zant. These are counties we've done similar regs for in the recent past.
The reason I ask that is because there seems to be a certain amount of skill and expertise and assurance that the court would want to know that that has been transferred. And if it's contracted out to somebody on an at-need basis, because obviously justifying having a person of that skill set on payroll could be cost prohibitive. But if the county engaged that service at that need that met the criteria and then ultimately had the responsibility transferred to them, it seems like it could suffice a need the county has.
Yeah.
Do you disagree? Or
No, I recommend frankly that an engineering firm be retained to do this, but the problem there is getting them to agree to turn it back around to you in a timely manner. A lot of times the engineering firms say, well, we're not going to be able to turn it around in less than 20 days. Well, that only leaves you 10 days to, and if he finds anything wrong, it needs to be done, and that letter needs to go out that day.
I have observed that there are retirees with certain skill sets who have established homes here in the county that may be an alternate resource, as long as they maintain their certification, that should satisfy the concerns of what the court might would expect.
I would recommend that you have someone who has a background in this sort of thing, who's familiar with, like I say, the plat. Before, we had preliminary plats, first reading, second reading. There was some counties were taking quite a long time to review and approve a plat. The developers have complained to the legislature, they have a little stronger lobby than we do, and has compressed it down to such a small window that has put the burden of getting immediate review by proper personnel on the county. That's another unfunded mandate that the legislature's not directly imposed on us, but for practical purposes, that's really an unfunded mandate.
Sure.
And that's why your fee structure is there to help you defray some of that cost.
Did
Joe,
you
do
talk
you have a
about the
question?
fee for filing the plan?
There are application fees, yes, ma'am.
We charge $100 right now.
Well, their review fees are separate from the filing fee.
Any further questions for council? Any other comments? All right, it seems that we have received public comments, and if there's no objection, it would be appropriate for us to close public hearing through comments on this particular topic of subdivision regulation and mobile or manufactured housing rental community property.
Get a motion
Yes,
to
sir.
close the public hearing?
Yes, sir.
I'll make that motion.
Second.
There's a motion with second. Comments? All in favor, aye. Any opposed? Motion carries. That takes us to a coming out of recess or reconvening of the meeting that this particular agenda has been posted for, and we do need a motion with a second.
Motion to reconvene.
Okay. There's a motion with second to reconvene.
Who seconded it?
Joe. All in favor, aye. And we now go back into our regular, well, actually, it's a special meeting, but it's a continuation of the special meeting. With that being said, we will consider and take possible action on the topic of subdivision regulations, including the regulation of the manufactured home rental communities pursuant to Chapter 232 of the Texas Local Government Code. Council, before there is a motion to that effect, is there anything that you would direct or advise the court to consider in that motion?
No, sir. I would point out that, this is your first opportunity to act on it. You may find after some experience that you want to amend the regulation. That can be done if it's a typographical change, if it's a designation of another individual to be your delegated authority. Anything that changes the substantive requirements of an applicant would need to go through another notice and review period. So don't feel like you're necessarily hamstrung or handcuffed to this particular document as it stands. You're able to amend it, but there may be the need to go through another public hearing to do substantive regulatory changes that require the developer to do certain things with their property.
Based upon your comments and respecting the document that's been presented to the court, with the understanding that it is subject to amendment at a future time, is there a motion to receive this particular subdivision regulation with the manufactured housing information included in it before the court? Is there a motion to receive? There is a motion. Is there a second? Second, Commissioner Blacksher. Comments or questions?
Mr. Bass, was on the RV park deals, you said you could have up to 4 before it's considered a
I
park.
believe that's correct.
And everything's grandfathered in with their.
Anything that's in existence now is not going to be affected by this regulation because it wasn't in effect when they were developed. It's whatever rules were in effect when a prior subdivision was approved. But anything from this day forward would be built under this regulation.
There are a number of what would be considered hunting clubs or deer camps with multiple amounts of temporary type of housing, i.e. recreational vehicles, that I think the commissioners know those locations within each of their precincts. If that is converted into some type of a housing community, not saying that it will, but just trying to think outside of just.
Any use that's in place now is not under this act, it's grandfathered, but any change of that use. So if something is expanded or it's made, it go from family RVs on a family-owned deer lease or whatever, but they start charging extra gun fees, or they do something that's different under what they've been doing up till now, then possibly this new regulation would apply.
Any additional comments or questions?
Yeah, I had one more question. I have a spot where some people they've cleared off some land. I'm assuming that's what they were thinking about doing, but in a park, RV park. Would that still be grandfathered?
Well, if it's just clearing off land, that could be any number of things. So no, it wouldn't apply to just.
So they would still probably have to go through this process
Yes,
once you get this done.
And, you know, as you're driving out through your precincts and you see something that triggers your interest, that looks like somebody's planning to start selling lots. We've had people put up signs, you know, lots for sale before there was ever a plat filed. Well, you need to talk to those folks and say, what are your intentions? Are you aware there's a subdivision regulation that's in place you're gonna have to comply with? And follow up on it. If they don't pay attention and they ignore you, then that's where the enforcement comes in. But it doesn't do you any good to have a regulation if it's not enforced. And if you don't enforce it, I'm not gonna say if you let one develop without coming under the law, but certainly you can't have a regulation and let some people violate it and other people not. You have to be uniform. So, you know, I would highly recommend that it's easy for me to tell you what I would do because I'm sitting in Austin, Texas. I'm not here in the community, but you're gonna have to be pretty hard-nosed up front at first until the community says, well, now there's a new sheriff in town, basically, a new rule. And you're gonna have to demonstrate that you're willing to hold them to it.
Yeah, I spoke with some counterparts in Hardin County, and they said that, the one I spoke to said that they made a mistake and went soft, and then tried to go hard. He said it's best just to go hard, and then you can back off, is what he told me.
This two tiers helps you some, because not every planned development, if you have 4 lots that front a county road, all you really need to know is there gonna be a drainage problem? Is their sewage gonna flow downhill and hurt somebody else? Is there necessary water and sewer accommodation? Other than that, it doesn't need to go, there's no roads to pave, but I think you ought to look at everything that comes to your attention. Subdividing land ought to be looked at, and that's where, if somebody brings a plat in, wants to file it, have you talked to the commissioner? And I would refer them back to the commissioner for that precinct first, and then again, you need to figure out how are we going to administer this program? And in the absence of a designated employee or a professional, it will come back to the commissioner.
You see, that's what we had been doing before I even put it on the agenda.
Right.
I would tell them they needed to talk to the commissioner.
Right.
But now you're saying when they file with us, the clock starts ticking.
If somebody brings it in and after today, if it's passed today, you say, well, have you complied with the subdivision regulation? If you're not, you need to go talk to the commissioner. And if they look at you and say, what are you talking about? Yeah, the commissioner's who you need to see. Now, I can't accept it for filing. It's not ready for filing. It's not finalized. It's not a complete plat.
If somebody's dividing up land like that, that is an exempt action on their part, they can still come to court and ask for the exemption certification.
And that would be the better practice for everybody, is if somebody thinks, okay, I'm developing lots to divide my mother's estate, but the children are gonna each get 20 acres. Well, that's a subdivision of land, but it's exempt. But they should come, file an application for exemption, and you look at it and say, yeah, this qualifies as an exemption. Sign and give them a certification of exemption. That way, you're protected, they're protected. Now, the tricky part is, like I mentioned, if then son number 2 wants to subdivide his 20 acres, he's not exempt forever. If he starts trying to subdivide his 20 acres, he comes under the act again.
Any additional comments or questions?
Judge, I need a clarification. So a few minutes ago, when you read out what the motion would be, and you said subject to the amendments that would have to go through readings and public hearings, does that need to be part of the motion? Or we
Counsel?
just,
I would not think so. I mean, that's inherent. It's just really, do we approve this ordinance and the manufactured home regulation? I think my comments were just to let you know that, you can make certain amendments without going through new notice and new public hearing. But you've got to look at what is it? Is it a typo? Is it clerical? Or is it substantive? If it's substantive, yeah, you got to probably give me a call and we'll go through those same procedures.
But as was presented is what we're acting upon today.
Correct.
So we do have the motion with the second that's on the floor. We've had comments and questions. Any additional comments or questions? Thank you, Donnie. So very valuable. Are you ready for the question? All in favor, aye. And it sounds like it's unanimous.
I'm going to present 2 copies, one to be filed of record and one to be kept available either in the clerk's office or wherever you choose, just for public inspection. But I'd like to have both signed, and there's
Put that on the website too.
so let me make sure. This one is the manufactured home regulation. Its signature page is one location on page 10. Thank you for it. And the regulation itself has 2 signature blocks, one on page 46, and one on page 16.
Yeah. Scribble your John Henry on that.
Sure, Jeff. Sir, are you sure?
The paperclip thing.
Pretty good.
Yeah.
You do pretty good, right? Which one of those I guess What's that page you got? Like it over there.
Oh, yeah.
We had a signature page on the
Several years after that second flood. Started moving in.
That's 46.
This is good.
General regulation. Yeah, that was
But your money, you got the heck about that.
I don't know of anything for executive session. If not, I don't know that we need to keep the meeting open. We're just going through the formalities of signing documentation. Is there a motion to adjourn?
Motion to adjourn.
Okay, all right, second. All in favor, aye?
Aye.
Okay, we will stand adjourned. And we can cut our broadcast off now. Thank you, ladies.
We got another meeting.
This conference is no longer being recorded.
So we're free to talk among ourselves.